you, Mr. McCormick. Thank you so much. It's a privilege to be here today, and I want to thank again all of the conference organizers for bringing us here in beautiful South Africa, the Ministry of Justice, UNODC, UNDP, the International Legal Foundation, and Legal Aid of South Africa. I've been asked to speak about cost effectiveness and sustainability, and obviously the U.S. has a lot of successes in the area of criminal legal aid. But as you heard this morning from the Associate Attorney General, we continue to struggle to really fulfill and achieve the goals that are set out in our Constitution and under international law. And obviously funding is a big part of the struggle even for us. I think there's a lot of misunderstanding as to how much money is actually spent on these services in the United States. In a 2011 UNODC survey, I just want to note that they assessed that the U.S. funding is the same as in South Africa, $2 per capita. So it is not as high, I think, as some of the speakers have referenced over the course of this day and a half. And from the outset, I'd like to give just a brief overview of our criminal justice system because it's quite varied and complex, and it also might indicate and demonstrate why it's difficult to talk about funding because we're a federalist country. We have federalism in our country, and that implicates how funding is assessed. So we have federal, state, and tribal jurisdictions, and we have different models of how defender services are provided in each. We obviously, I think many people talk about this, we have the public defender system, which is where people are actually government employees. We have a contract system. This is a newer system that's in the U.S. where lawyers and law firms bid with local governments to perform the defense for their communities. We have assigned lawyer systems. This is the oldest system in the U.S., and it's where the court or civil authority on behalf of the court assigns cases to lawyers based on the complexity of the case and the experience of the lawyers. And there's obviously, this demonstrates many models, and it allows us to measure the cost effectiveness of each and their sustainability. And there's much discussion in the U.S. about which system is best, and because we have so many variations, we can demonstrate where it works and where it doesn't work, and it's not that just one of these is the right model. In fact, we have examples of any one of these that work well, so it makes it very difficult. And it's important to note that our federal defender system is often considered to be the best in the United States, and it's a public defender model. But we should note that over 90% of criminal cases in the U.S. concern violations of state law. So while the federal system is well-funded, well-resourced, and it's obviously something that we point to as being a model in the United States and perhaps elsewhere, it's just a small sliver of the criminal work that's done in the U.S., the criminal defense work that's done in the U.S. So with that background, I'd like to turn to the UN principles and guidelines. I don't have a presentation here. Instead, if you have it with you, I'd like to ask you to turn to your survey or pamphlet and to turn to Guideline 12, which is on page 23. Obviously, if you don't have it, no worries, you know where to find it. But it's Guideline 12, Funding the Nationwide Legal Aid System. And I'll go through this rather quickly. I'm not going to read it verbatim. You can do that. But I will provide some context as to how in the United States we have examples of efforts to demonstrate how the standard is worked in the U.S. So paragraph 60 starts at the bottom of 23. It starts with discussing, the recognition of the benefits of legal aid, that states should make specific budget provisions for legal services, commensurate with their needs. So again, we have these different systems. We have a federal system, and in that case, we have annual appropriations from our Congress. This is going to be the most resourced source of defense work done. In the 2015 budget, which is to come, it has not yet started, it may not pass because our Congress has a difficult way of sometimes of passing the budget. It's $1 billion, but that's for 94 offices, and it concerns not just salary, but conflict counsel, investigation, training, experts, administration. But that really is the gold standard, because by comparison, in the state system, and again, we have 50 states, the District of Columbia, territories, the states all handle this differently, and it's supplemented by federal funding. But the state system, we have a census from 2007, another one that's being collected now, so I don't have the most recent data. but in 2007, a federal census assessed that there were 957 offices across the United States, over 5.6 million cases, over 15,000 attorneys, but $2.3 billion. So again, 957 offices, 2.3 billion, that's the state. The federal, it's 94 offices and 1 billion. It's very vast difference here. And as I said, there are some federal funding streams that try to support this work. It's administered sometimes by a formula based on the size of the state, the population, private statistics. But anyway, I won't go into that. And then in the tribal system, I'm not going to talk a lot about that, but we have tribal courts for our Native American communities. Each tribe handles it differently. Funding there is very low, and also they're supplemented by federal funding. Okay, to move on, paragraph 61, it lays out what states should do. So it's discussed in paragraph A. It should establish a legal aid fund, and it describes a whole variety of different ways that legal aid might incorporate other aspects of providing the service, like university law clinics, paralegal organizations, etc. In the U.S., criminal and civil legal aid are handled differently and funded differently. There's a requirement to fund criminal defense by the states because we believe this is an obligation of the country and of the state. So as a policy matter, we do not talk about pro bono or law school clinics fulfilling this need. Obviously it occurs, but again, from a policy standpoint, we don't incorporate this consideration into how we should fund criminal defense work. At certain appellate stages, there's of course, unfortunately, no right to counsel. We call this at the post-conviction proceedings. So there's a lot of pro bono and other activities done. But generally, we consider this again to be a requirement we're cautious to talk about this because we don't want to supplement what is in fact a government function. For civil legal aid, there's no right to counsel. That's often something that people don't recognize in the United States system. So one thing to note there, though, is that with the largest funding stream that exists, it comes from the federal government, and in fact, there is a set-aside that about 13% of the funding that comes from that must support private attorney involvement. Paragraph B then discusses identify fiscal mechanisms for channeling funds, allocating a percentage of the state's criminal justice budget, and using these funds recovered from criminal activities through seizures or fines to help civil legal aid for victims. Again, we have these large grants that come from the federal government and goes to the states, and they're available for a wide variety of criminal justice purposes, including defense. But the way we have our federalism set up, we cannot, as a federal government, require that it be used for any particular purpose area. So often the states choose to use the funding primarily for the law enforcement function, for police, for prosecution, etc. And some states use defense, but this is a difficult thing for us to sort of measure and require. And the second part of that paragraph I read discussed about using fines and to cover legal aid for victims. We do have victims of crime funds. We have a federal one and we have state ones, and some of those funding is used to help support legal services for victims of trafficking, etc. And then of course states have their own funds to supplement that. The next paragraph talks about helping identify and putting incentives for lawyers to do this work. In the US, it's very expensive to go to law school. Many of us have funded that through debt. I think that's something also a lot of, other countries find remarkable. So to encourage lawyers to not go into private practice where obviously they might have a better salary, we encourage people to go into public interest through obviously people choose to do that through their own values, but there are loan repayment programs and there are some that are federally funded to support public interest work, including being a prosecutor and a defender. Then the next paragraph talks about parity. In a sense, it talks about distribution of funds between prosecution and legal aid. This is a very difficult thing to talk about in the United States, especially because the idea that law enforcement may have to research or investigate a case, and prosecution has to assess whether or not to take the case. And so often there is a sense that, well, it's okay that it's not parity or perfect parity, but again, we might push against this. And also there's an American Bar Association principle on this. I'll come back to that in just one moment. The next paragraph, the last one, talks about the budget for legal aid should cover the full range of services to provided to persons detained. Again, this goes to the idea that effective criminal defense isn't just a salary for a defender. It includes investigation, evidence, experts, all of these sort of aspects that create a proper case. And also it depends on what stage in the prosecution. We in the US, we call it all critical stages. There's a lot of disagreement as to what that might mean exactly. So this is sort of the scheme of the Guideline 12. I wanted to give context as to how we do it to demonstrate we have a variety of ways to try to do this work. There's no one way that actually I think from our practice we would say is the best way. And a complement to these guidelines, you've heard about them I think in other sessions, are the American Bar Association's 10 principles of a public defense delivery system. Principle 8, I think, is the most important one here. It again talks about parity. So there's a constant discussion about trying to provide the same resources for prosecutors and defenders. It's a struggle. It's a big struggle and sometimes quite difficult to engage in that conversation. So I'm going to be very brief. I have only a few minutes, for less than 2. And just the next thing I'd like to say is how to proceed about cost effectiveness and sustainability. And so really this is the idea of how do we then take all these variations of the way we try to implement and support criminal defense work in the US and know what works best. And you'll hear it on other panels. It's through data evaluation and measurement. So collecting data, studying how to assess our scarce resources. We're in an era that I think many of your countries have as well of evidence-based research, that in fact, to know how to spend the money, you must first study it, pilot it perhaps, review it, and assess as whether or not that was really an effective way to spend your dollars. Obviously also, there's cost savings in providing counsel, so being able to make the case that when you put in defense and adequate defense at the front end, you have cost, there's value to that based on human rights and the notion of helping each other to sort of move beyond our problems in life. But also the idea that in fact, it saves money for the government. So you have decrease in delays in court proceedings, decrease in pretrial detention, which might impact an individual losing work, losing even their children because they're away from them. Wrongful convictions, obviously, which have to be compensated later, decreases burdens on prisons because of the cost of beds, etc. So this remains a difficult topic to address and resolve. And I'd just like to point out that we have a lot of research that we've already done that may or may not be helpful and beneficial to your countries. But we encourage you to take a look. This should be on, this is unfortunately not, it's justice, and you're obviously free to come to me, justice.gov/ATJ. There's a database there of research that's already been done and assessed, and you may be able to learn from our successes and our failures as to what not to figure out in your own systems to improve and better criminal defense. So with that, I'll stop. Thank you very much.